All right, welcome everyone. Thank you for joining us for today's webinar. So my name is Beth Cohen-King, and I'm the Marketing Director at Margolis & Bloom. Margolis & Bloom works with its clients to find the best estate planning or elder law solution for each client's unique situation and goals. We bring to the effort 30 years of experience and a commitment to providing the highest level of personalized service. So today we are presenting Asset Protection for Seniors, Part 2, presented by Harry Margolis. Don't worry if you missed Part 1. We do have a recording available on our website at margolis.com. And if you go to under the Resources tab at the top, you will find webinars and events in the drop-down menu, and you can find it from there. Please feel free to reach out to me if you have trouble finding it. And if you have questions during the presentation, please type them into the question box in your control panel on the right side of your computer, and we will have time to answer questions at the end. So now I want to turn the time over to our presenter, Harry Margolis, and if you want to know more information about him, his complete bio is on our website as well at margolis.com. So with that, I will let you take it away, Harry.
Thank you, Beth. Good afternoon, everybody. So those of you who participated in Part 1 know that in Part 1 we covered protection of seniors from fraud, from elder abuse, from internet scams, and from their own potential of incapacity. And then we also talked about long-term care insurance. In Part 2, today, we're going to talk about MassHealth and protecting future generations, children and grandchildren. And in MassHealth, just so we're all on the same page, we're going to talk about advanced planning. We're not going to talk about crisis planning, what happens after somebody needs care and needs to apply for MassHealth. That's a whole other topic which we'll cover in a future webinar. So this is just about advanced planning today. So, with MassHealth, as you probably know, MassHealth covers nursing home care, and it has become the long-term care insurance of the middle class. So if you don't have long-term care insurance, or you don't have enough money to just pay privately for your care, if you end up in a nursing home, then MassHealth can cover your care if you qualify. But it's important to understand the rules, which can be extremely complicated. You should also be aware of a couple other things. One is that fewer and fewer people are actually going to nursing homes these days, and when they do, they don't stay as long, and that's because there's a lot of alternatives to nursing homes in terms of assisted living and home care. So it's a good trend, but complicates the picture because MassHealth covers some assisted living and some home care, but it's much more complicated. And it usually doesn't cover everything. And for instance, in assisted living, it may cover cover you once you qualify, but the assisted living facility won't. First of all, some assisted living facilities accept MassHealth and some don't, and those that do may have a certain limited number of beds or rooms that are available to be covered by MassHealth. So you have to get on a waiting list. And for home care, there's about half a dozen different programs with different rules and different benefits. So we're not going to get into either of those today because they're very complicated and build to some extent on what we're going to talk about today. And in addition, you can't really plan ahead as much for those, so it really relates more to the crisis planning side of things. So today we're going to talk about the basic rules of MassHealth for nursing home care and how you can prepare in advance. So the main rule is you have to be poor to get MassHealth. So what's poor? And what poor is you may only have $2,000 in what they call countable assets. And if you're married, your spouse is allowed to have $123,600, which is an odd number. It's an odd number because they change it every year to reflect inflation. So together you can have $125,000 in countable assets. So what's countable? And basically everything's countable except your home. There are a few other exceptions which we won't go into, but your home is non-countable as long as either you have a spouse living in it or its equity value, so its value, fair market value less any mortgage, is under $858,000. So that's the main rule. You got to get under those amounts. The next main rule says that if you transfer assets to get there, so they don't want you to say to have $300,000 today, to give away $175,000 tomorrow, and the day after tomorrow say, well, start paying for my care because now I'm down at $125,000. I'm talking about a couple here. So they say if you transfer assets or your spouse transfers assets, you're going to be ineligible for a period of time, and the amount of time of ineligibility gets adjusted with inflation as well, and currently is $10,767.50 is the figure you use for every $10,767.50 you give away. You're ineligible for benefits for 1 month. So that's the basic rule, but it can get kind of complicated because, so let's say you give away $107,000, which is going to make you ineligible for 10 months, but the question is, when is that 10 months? And the way it works is the 10 months doesn't begin until you move to the nursing home, number one, and number two, you have spent down to $2,000 if you're an individual, or $125,000 if you're a couple. So here's an example of how this works. Mr. Green, on July 1st, 2016, 2 years ago, gave away $107,675 to his children, causing 10 months of ineligibility. A year later, last July 1st, he moved to a nursing home. And a year after that, this coming July 1st, he runs out of money because he's been spending it on the nursing home. It's at that point that the 10 months begins. Now you may say, well, that doesn't make any sense because why should it begin then when he doesn't have any money, so clearly he can't pay, but that's how it works, and sometimes it leaves nursing homes high and dry because they can't get back that $100,000. And there are some hardship provisions, but that's basically how it works. But what it means is that if you give away assets, assume that you're going to be ineligible for benefits for the next 5 years, especially if you're doing it in advanced planning. And that's because there's a 5-year look-back period. So if you give away $1 million and you apply for benefits 5 years and 1 day after you've done that, then they don't look at that transfer. But if you give away, as in our example, $100,000 or a bit more, and you apply within those 5 years, you're going to have a period of ineligibility starting once you run out of money. So since you don't have to report gifts that are made more than 5 years prior to application, it's best in terms of advanced planning to try to make sure that you always have enough money left to cover your care, whatever it may be, over that 5-year period. Of course, you don't know exactly because you may be totally healthy when you make the transfer, or you may be beginning to show some signs of incapacity or disability, in which case you definitely have to make sure you have sufficient funds remaining to cover yourself during that period of time. So those are the basic rules to work with. So now let's talk a bit about what we are going to do to protect assets. And I talk here about home equity, which I mentioned earlier, that home is not counted as an accountable assets in Massachusetts if the equity value is under $858,000. And as it says here on the slide, that mostly applies to unmarried nursing home residents. Unmarried also means widowed, so they're not married when they're applying for benefits. Because if your spouse is still living in the home, then there's no limit on the equity value. But if you're single, or in the rare case that both spouses enter a nursing home, then the equity is limited to $858,000. Now, so first question is, say your house is worth more than $858,000, which makes it countable. What do you do? So this is actually a bit of really crisis planning, because if you plan ahead, you've already protected the house and it doesn't matter what it's worth. But if you haven't, At that time, you enter a nursing home, you have a house that's worth $908,000, it's $50,000 over the asset limit, and if you don't do anything with the house, you can never get MassHealth coverage because you always have this countable asset that's worth $50,000. So you got to get rid of that. So what can you do? One, you can sell the house and spend down the proceeds, but that's probably not what you want to do because you want to get MassHealth because that's going to be cheaper. The next thing, which may be the best thing to do, is borrow the $50,000, get a home equity loan, borrow $50,000 on the house to bring its value down under the equity limit of $858,000, spend down that $50,000, but that's all you'd have to spend down. Argue that the valuation is wrong. And so there are many ways to value a house. There's the tax valuation, there's an appraisal, there's a broker's valuation. So even though you may know they can sell this house for $900,000 or more, the tax value may be less, so you can use that. Or you may be able to, if you can't get a home equity loan because of the situation of being in the nursing home, there's also the possibility of working out a deal with the nursing home. So maybe they'll take back a mortgage for $50,000 to reduce the equity in the house. So these are all things you can do if you didn't plan ahead. But our discussion today is really about planning ahead. So we talked in our last webinar about buying long-term care insurance. If you buy long-term care insurance and you have enough coverage, then you don't have to worry about MassHealth. Here's another idea. Why are you protecting these assets anyway? So if you're a married couple, there's usually a number of things. If there's a healthy spouse, there's a number of things that can be done, even after the fact, even after one spouse goes to nursing home. But if you're single, you're really protecting assets for the most part for your children or your grandchildren. Because once you're in a nursing home, if you can qualify for MassHealth, or if you pay privately and spend down your money, it's not going to affect you one way or the other. But if you pay privately and spend down all of your savings, there'll be less that you're going to leave your kids. So another possibility, if what you're really wanting to do is make sure you leave them something, buy life insurance. That's what it's for. Now, the problem with life insurance is that if it's a whole life policy, then it has a cash value, which would also have to be spent down. But if you buy it through an irrevocable trust so that you don't own it, then it's not something that has to be spent down. So that's a possibility. But then the next thing that a lot of people do is they put their house in an irrevocable trust, as I say here, especially if it exceeds the $858,000 state limit. So, so I'm going to go back. Sorry, I should have more slides on the irrevocable trust. So let's talk about that, and let's talk about why we're doing this and why I'm also going to talk about life estates in the next slide. So one thing you can do to protect assets is just give them to your children now. If you give it to your child and 5 years from now you're still healthy and you haven't gone to a nursing home, that house is protected. It's not a MassHealth issue. It doesn't have to be reported, and there's no problem with that. We generally recommend against doing that for two reasons. One is we never trust the kids. So they could own the house, and a lot of things can happen. They can get into financial trouble themselves. They can get divorced. They can pass away, and their interest passes to their spouse, who may or may not stay on good terms with or close to, and they can decide that it's time for you to move out of the house before you're ready to do that. So these are all risks in just giving it away. In addition, they lose a potential tax benefit of your keeping the house, at least you're keeping it for tax purposes, and that is what's called a step-up in basis. So let me give you an example. let's say you bought the house for $200,000 20 years ago, and today it's worth $600,000. If you sell it, you will have capital gain of $400,000, and the tax on that, depending on your tax bracket, could be up to $100,000 between both the federal and the state tax on capital gain. And for you, if you sell it, you can exclude $250,000 of the gain because it's your house. If you're married together, you can exclude $500,000 of the gain, so there'd be no tax. But if you give the house to your children, they get it with what's called a carryover basis. And the basis is the amount you paid for it, that $200,000, plus any improvements that you can show that you made to the house. But let's assume for our purpose that there are no improvements. They get it as a gift. They sell it. It's not their home. They have to pay that up to that $100,000 in capital gains taxes. But if instead they inherit the house from you, then the basis becomes what's called a step-up basis. Instead of a carryover basis where they receive the same basis that you had in the property, they get the basis gets changed to value on the date of death. So if the value on the date of death is $600,000 and they sell it for $600,000, they have no capital gain, they have no tax, they've saved $100,000. So this is what usually convinces the kids that they're coming to say how can we save mom's house, that she shouldn't give it to them directly, because if it's a direct gift, you're insuring $100,000 of capital gains taxes in our example, to protect a house against the possibility of needing Medicaid. The other thing I probably should put a slide on here that you need to know for why we're doing all this is that while you can protect the house with, not protect the house, but the house does not have to be sold and spent down if its equity is under $858,000. As I often say to clients, MassHealth doesn't get you coming, they get you going. So you can keep the house, you can get MassHealth, and that's fine. But then MassHealth has a claim against the house for whatever is paid for your care. So if the house is in your name, when you die and it goes through probate, MassHealth is waiting. So if it's paid $200,000 for your care during your life, then it's going to have a claim against the house to recover what's paid off. So what we want to do is protect the house from that claim, that so-called estate recovery claim. So the best way to do that, now that we're getting back to our slide, is to put your home in an irrevocable trust. An irrevocable trust is a trust that can't be changed once you've created it. You are not the trustee, except perhaps for the income that you can still receive. So if it's a home, you can receive rental income. If it's investment stock or CDs, you can get the interest or dividend income. Except for the income, you can't touch it once it's put in. And if it meets these and some other rules, then it's non-countable after that 5-year wait. So that's often the best way to protect assets, especially assets that have appreciated, in order to avoid the tax on capital gain. So there's a trust, but the other potential thing you can do with a house is a life estate. And a life estate is simpler than a trust because it's simply a deed to your children with the retention of the right to live there for the rest of your life. And unlike a direct gift to your children, even though this is a gift, it's not a complete gift, they can't sell the house without your permission. In addition, you're entitled to any rent that may be earned on the property. And in addition, they can't kick you out because you have the lifetime right to live in that house. They have no legal right to basically not ownership, but of possession of the house while you're alive. So a life estate is somewhat simpler than an irrevocable trust to set up. The main problem with a life estate is if you want to sell the house. So say you move to a nursing home and your kids don't want to have the trouble of maintaining this house during your life, and they want to sell it. If they sell it and the house is in an irrevocable trust, the proceeds stay in the irrevocable trust, and they continue to be protected. If it's a life estate and it's sold, then the proceeds are split. So some of them go to your kids because they already have an ownership interest, even if they don't have right to possession. But some of the proceeds come back to you because you own this life estate interest. And when you receive that money, you have to go off of MassHealth and spend that money down until it's spent down. Now, the older you are, the smaller your percentage interest, but still some money that's not protected. The other potential issue with a life estate is even though your kids can't sell their interest because there's no market for it, or it can't be, and your interest can't be taken if they run into trouble with a divorce or a lawsuit or anything like that, that can still complicate things, especially if they die and their interest goes into the probate estate. These things can get complicated in ways that don't happen with a trust. And finally, if you do want to sell it, we've had a case like that where a woman did want to sell her house and her kids said no, they would still have to sign the deed with a life estate. They don't with a trust. So moving on to non-house assets. So if you, as we alluded to before, with other assets such as stock, bonds, bank accounts, those can also be protected through an irrevocable trust. So trusts can be very good ways to protect assets. The other option, of course, is to just give them away to your kids and wait the 5 years, but just always make sure you have enough money for whatever you may need during that time. And if you are giving money to your kids, think of it as really giving it to them, not as them holding it for you just in case you need it, because that might or may not work out. You have more than one child, it may create a lot of problems between them. If some of them stand by you and some of them don't. So it's better not to create any ambiguity and think that a gift is a gift, but if it's to protect assets, use a trust. Finally, since everyone's situation is different, there are some exceptions to the transfer rules that were beyond the scope of this discussion, and everyone's priorities are different. Before embarking on any of these plans, I strongly recommend consulting with an elder law attorney. So that's just summarize for long-term care planning. If you're not buying long-term care insurance and can't afford to self-pay, and you want to take steps to protect assets, then what you can do is really transfer them now and wait out the 5-year period. If you want to protect those assets from taxes or any other risk, the best thing to do is use a trust, and sometimes for a house, a life estate. So we're going to switch gears now and move on to what we call family protection trusts, which are sometimes called generation skipping trusts or spendthrift trusts. So the issue here is that we live in a very dangerous financial world. As the slide shows, people can run into bankruptcy, they can become disabled, they can pay estate taxes. Now, almost nobody pays federal estate taxes these days, since the threshold for federal estate taxes moved up to $11 million and $22 million for a couple, but the threshold for Massachusetts is just $1 million. People make bad investments, as we talked to before, in terms of giving money to your children. They can be subject to lawsuits, they can pass away, they can make bad spending choices, or they can get divorced. Now, the law has in it, has always had in it, a way to protect assets in case any of these bad things happen to your children or grandchildren. And it's a device that's been used by the wealthy forever, in Massachusetts especially. People have been creating trusts, and we have trust companies that do this kind of work. We've had them for centuries, apparently ever since captains would go off on their clipper ships, and whether it's the sugar trade or the slave trade. Unfortunately, there were people in Massachusetts who set up trusts to protect their assets for their families in case something happened to them. So those trust rules exist and have always existed, and are now beginning to be used by people who aren't quite as wealthy as the people who used them in the past. And the main thing you can do is, rather than leaving funds outright to your children and grandchildren, you can leave them in trust for their benefit. And if the trust is properly written, they can get the benefit of those funds, but the funds won't be subject to claim by anyone. So they won't be subject to claim if they get sued, if they go bankrupt. If they pass away, the funds will stay in the family. If something happens to them and they need to apply for public benefits, those funds won't be counted. They will, and then there's a recent major case in Massachusetts called Vantage Deal, which said that they won't even be counted in determining just a distribution of assets in the case of a divorce. So there's a lot of protections, but there's some trade-offs. So, and the biggest trade-off is, in order to get those protections, you can't control the money. So you have to have somebody else as trustee with discretion on how it is transferred out. So that's the biggest trade-off, and there's some costs to that, because if you can use a family member or somebody volunteering, but you're probably better off using a professional trustee, and they'll charge a fee of usually about 1% a year to protect those assets. Now, these trusts can be written in a lot of different ways, and as I said, the strongest trust is where there's an independent trustee who has total control over distributions of the assets, and that's pretty much ironclad. Now, we have drafted trusts that are somewhat less restrictive, but the trade-off, and so less expensive to operate, and gives the family member who's the beneficiary somewhat more control. But the more control you give them, the less protection there may be. So here's some choices you can make. So the first is the choice of trustee, but we've written a number of these trusts with the idea that we allow the child to be the trustee, to manage the funds, and to even receive the income from those funds, but they can't make distributions of principal to themselves. So under the terms of the trust, they don't need to hire an independent trustee immediately. They can be their own trustee, manage the funds, and then if they ever need access to principal, then they have to appoint an independent trustee. And that works if the child follows the rules. So that's the big risk, because there's no one who's going to stop the child from dipping into the trust if they're the only trustee. And if they start doing that, then all the protections go out the window. So that's a real issue with this, is whether the child will follow the terms of the trust. As we said, the child cannot control principal distributions, and the trust can either, you can write in a number of ways. You can give the trustee complete discretion on making distributions, or you can be very specific about what types of things those distributions can be made for. Along those lines, you can say that the child is the only beneficiary, or the child and their spouse are beneficiaries, the child and your grandchildren are beneficiaries. So these are just some of the choices that have to be made in writing these trusts. You can also decide who can change the trustees. If the child can change the trustee, that's probably fine, but it's a little more ironclad if you give that power to somebody else. is not a beneficiary. So a few other benefits to these trusts, in addition to what we've talked about. There's the asset protection, there's the keeping the funds in the family line. It also, these funds, the trust can be written so that it's not in the child's estate, so it's not taxed when they die, which again is less important today than it used to be. If you have an IRA that goes into the trust, so it's an inherited IRA, you can make sure that the child doesn't withdraw too quickly and pay taxes on it too quickly, that they withdraw during their lifespan. And while the recent changes to the bankruptcy law provide a lot of protections for your own IRA, it's been ruled that those protections from creditors don't apply to inherited IRAs, so the trust would add those protections in. So these are all of the protections you can get from a family protection trust, and why we discuss it with virtually all of our clients. For some, they matter more than others. There's a balance, of course, of the costs and trouble of creating and funding one of those trusts is a cost, and there's also the issue of the kids might just want control, do what they want with it, and not worry about any of the protections. On the other hand, you have this one opportunity in creating a trust by a third party, the parents for the children and grandchildren, that can provide a lot of protection. So it's for each client and their family to decide what they want to do. So between these two webinars, we've covered a lot of ground on different things you can do and your families can do to protect yourselves and your families when you become older, whether for whatever reasons, whatever we're protecting against. And it's for every client to determine what makes sense and what they want to do. And kind of the backdrop of all of this, as we say on this slide, is someone who's younger who doesn't take steps to protect themselves, their funds, their family. If they're still working, they can always earn back whatever they may have lost. But most people, when they retire, get more nervous because what they got is what they got. They probably stop working, or they may only be working part-time, and this has to last them through, and they don't know how long they're going to live. They don't know if they're going to be healthy for their entire lives. They don't know kind of what bumps in the road are going to come up. So it's more important for them than for younger people to take steps to protect assets. So we can take some of these measures to plan to mitigate that risk, both for ourselves and for our children in the future. So we can, if you have questions, I think we said this in the beginning, but if you have questions, feel free to type them in. I think Beth can explain how to do that.
Sure. Thank you, Harry. So I think obviously there are a lot of ways to protect assets for future generations. And I wanted to note that in the control panel, we've placed our legal guide in the box for you to download. Hold on one second. Here, I got it. So if you go to the control panel, you'll see there's a legal guide in there that you can just click on and you can download. And I guess we're ready for some questions. And also, if you aren't able to do it from the webinar, we do have the legal guide on our website under the resources section. And also, we want to continue the conversation, so you can use askharry.info as more questions arise. So let me see here. Okay, so the first one, do you recommend a life estate for the primary residence that is transferred to an irrevocable trust, or do you prefer an alternative approach?
So we've seen people do a combination, basically, of the life estate and an irrevocable trust, where they retain a life estate but transfer what's called the remainder to the irrevocable trust. We don't really do that because we figure if you're going to go to the trouble and expense of having irrevocable trust, I would just have, that's all I would have. I wouldn't have the life estate as well. There have been attacks by MassHealth against irrevocable trusts that retain a life estate or right to use and occupancy in the trust document itself. So we often do is have a side use and occupancy agreement to make sure that your trustees don't throw you out of the house. It's probably not necessary now because after much litigation, it's clear from the courts that it's okay to give you the right to live in the house right in the trust without them making it a countable asset. So, so what I would do if you're going to use an irrevocable trust, just use an irrevocable trust and don't combine it with a life. It's just complicated. It doesn't solve the problem of what happens to the proceeds when you sell the house.
Okay, there's actually also a question that came in via email.
Oh.
So how is the income from an IRA, SPIA treated in the overall income eligibility for the Mass PACE program?
Oh, PACE. I'm not the expert on the PACE program, and we should probably have Tricia D'Agostino in our office do a presentation on all the community benefit programs. But I would say, that said, here's my guess, is that it's not, so they're different. So an IRA is an asset. So it's so the income is just income earned on it, just like any other asset. In fact, yeah. So and if you have to take required minimum distributions, that should not be treated as income for benefit programs because it's really just a distribution of an asset. So the income is just the interest or dividends earned. An SPIA is different because that's a single premium annuity. So an annuity is may or may not be a transfer when you purchase it, but the payments coming out of it are considered income.
So what is the first step after the 5-year period has passed of putting house in a trust?
Well, once you put the house in the trust and you wait out the 5 years, you're good. Enjoy your life. There's nothing else you need to do. I'm not sure if that was might have misunderstood the question, but that's you're in good shape then.
Although after 5 years look back, MH does not look at the transfer, it still has to be disclosed on the application with supporting docs.
So, yeah,
okay.
MassHealth,
Yeah.
So when you, right, so even though the transfer itself is exempt, so if you just gave the house or another asset to the kids, you don't have to report it after 5 years. If you have a trust, you do have to report the trust. They'll ask questions about it, but even if you have to disclose that you made a transfer more than 5 years ago to a trust, it doesn't matter. So they'll look at the trust document itself, but they won't look at the transfer.
Okay. Another one. If you give assets to your kids, do you file gift tax returns if exceeds the annual exclusion amount?
So this is something of a gray area. So if you give somebody, any individual, more than $15,000 in a year, you're supposed to file a gift tax return, at least that's what it says on the books. And that uses up some of the money you can give away tax-free at death. However, since you can give away $11 million, there's very few people who will have given away either $11 million during life or $11 million combining their lifetime and taxable gifts with their estate. So if you're not in that kind of group of people who now need to worry about federal estate tax planning, no one's going to come back and question you if you didn't file the gift tax return. So, so as your lawyer, if I were your lawyer, I would have to tell you that the law says you're supposed to file a gift tax return, but I think I'd also counsel you that there's no consequences if you don't.
If a house is put into an irrevocable trust, is there a 5-year waiting period? Is it treated like a gift?
Yes.
Okay.
Let me go back to that the last question on the gifts. There is an issue in terms of gift taxes in terms of the Massachusetts estate tax. So as I told you earlier, the Massachusetts estate tax threshold is $1 million. Now, what you're supposed to do in determining whether you exceed that $1 million threshold is include both what's in your estate and what you've distributed in terms of taxable gifts. So if your estate is $900,000 when you died, but you made $200,000 of taxable gifts during your life, together that adds up to $1.1 million. So you are over the $1 million threshold, and you have to file an estate tax in Massachusetts, even though you're under $1 million. So it does factor in. Now that's true whether you've actually filed a gift tax return or not. You have to report those taxable gifts on the estate tax return. So if you filed the gift tax returns, then at least you have a record of it. If you haven't filed filed those, then you still need to report it on your Massachusetts state tax return.
Okay.
It's hard to read these questions the way they set it up on the program.
When assets are transferred into a revocable trust, is there a step up in basis at death of these assets in the trust?
Yeah, I should have been more clear about that. The answer is yes. The trust has to be drafted so that occurs, but if you're using trust for this kind of purpose, they will be drafted in that way.
Okay. I think we have time for one more. Exactly. In an irrevocable trust where the donor names their adult child as a beneficiary to receive donor's home, may donor and/or trustees later add the adult spouse as a beneficiary?
So that's a gray area. So I guess it depends. There's a certain number of ways of doing this. So the trust must be irrevocable, so you can't change it. You can have in the trust what's called a power of appointment, which allows you to make changes in beneficiaries. There are both lifetime powers of appointment, which we have not used in our office, though I've seen, and testamentary powers of appointment that occur at death, which we do use, and which is one device to get a step-up in basis. So certainly the spouse could be named a beneficiary at the death of the donor through exercise of the power of appointment. I guess I'd be pretty wary of making them a beneficiary or even having the ability to make them a beneficiary with a lifetime power of appointment, because that could render the whole trust countable. You could potentially make them give the donor or the trustee the right to make them an income beneficiary, and I think that's possible because that doesn't change the principle. So I guess the answer is, if it's a lifetime power of appointment, it should be only permissible to give the spouse income, but if it's a testamentary power of appointment, it could be both income and principal.
Okay, I think that's it. I did see one other question. That legal guide, if you're still on, is in the handout section, so you should be able to see it there. But again, if not, you can download it at margolis.com/legal guide, or if you just look to see our resources section on the website, you can find it there. So thank you to everyone for attending, and if you have any topics that you're particularly interested in, you can get in touch with me so we can cover it for later webinars. If you have specific questions, askharry.info is a great site. Harry will answer all of your questions there quite thoroughly. So, yeah, thank you to Harry, and we will have a recording of the presentation available if you weren't, if anyone wasn't able to attend, or if you want to pass it along. And you give us about a week to make sure we have all the edits and everything. And please see our contact information if you need additional follow-up. Thank you so much, and enjoy the rest of the day.
Thank you all.